The Establishment Act answers the question as to how the United States Constitution requires the government to respond to non-secular, self-asserted sex-based identity narratives like homosexuality and transgenderism and to sexual orientation orthodoxy. The bill is based on the following framework. The United States is a constitutional republic, which means the federal and state government cannot create or enforce policies that conflict with or violate the United States Constitution. Every member of the judicial, executive, and legislative branch are bound by oath pursuant to Article 6 of the United States Constitution to not create or enforce policies that violate the United States Constitution, regardless of their political affiliation and the desires of their constituent base. The Establishment Clause of the First Amendment of the United States Constitution states that the government shall create no law respecting the establishment of a religion. What this means in plain English is the government cannot cultivate policies that have the direct or symbolic effect of establishing one national religion that's mandated. The government is to remain neutral on matters of religion and not establish an official national religion. The Free Exercise Clause of the First Amendment prohibits the government from interfering with a person's belief in a particular religion and the practice of that religion, with some exceptions. The Establishment Act provides the legal definition for the term religion. All religion amounts to is a set of unproven answers to the greater questions like how did we get here, what should we be doing as humans, and what happens after death. A religion can be theistic, involving belief in God, or non-theistic, involving disbelief in God. The Establishment Clause of the First Amendment was never designed to just prohibit the government from respecting the edicts of institutionalized religions like Christianity and Judaism. The Establishment Clause was designed, if not more so, to prohibit the government from respecting the edicts and doctrines of non-institutionalized religions like secular humanism. Secular humanism is also referred to by scholars as Western postmodern individualistic moral relativism or expressive individualism. Secular humanism is the non-theistic faith-based belief that there are no moral absolutes and that man is God, putting man at the center of the universe. According to Secular Humanist Manifesto 1 and 2, secular humanism has many denominational sects. The evidence shows that Black Lives Matter, Planned Parenthood Federation of America, and the LGBTQ cult are denominational sects of the religion of secular humanism. The LGBTQ cult meets the legal definition of a religion because it involves a closed system and a community that is full, organized, and has a private moral code by which its members can guide their daily lives by. Just as Christianity has the cross, Judaism has the Ten Commandments, and Islam has the Star and Crescent, the LGBTQ secular humanist cult has a rainbow-colored flag to represent their faith-based values. The Establishment Act is based off of sworn statements provided by ex-gays, medical experts, religious experts, and persecuted Christians, all of whom have testified under oath that there is no proof of a gay gene, that the idea that sexual orientation is predicated on immutability is not proven, but rather homosexuality, transgenderism, and sexual orientation are an orthodoxy, a doctrine, an ideology, a worldview that's inseparably linked to the religion of secular humanism. They are not a medical science or a benign philosophy, as many leftists pretend in order to gain personal political power. The United States Supreme Court, first in Torcaso versus Watkins, and then in subsequent cases, and just about all of the Federal Court of Appeals, have found that secular humanism is a religion for the purpose of the First Amendment Establishment Clause. The Establishment Act is predicated on the idea that when someone says that they were born gay, that they were born in the wrong body, or that they came out of an invisible closet and were baptized homosexual, those are a series of unproven faith-based assumptions and naked assertions that are implicitly religious and inseparably linked to the religion of secular humanism. Therefore, the Establishment Act states that the government is prohibited from creating or enforcing policies that promote, respect, favor, or endorse LGBTQ ideology or sexual orientation orthodoxy, because those policies fail the three prongs of the Lemon Test and therefore violate the Establishment Clause of the First Amendment. The Lemon Test is a three-pronged test created by the United States Supreme Court in Lemons versus Kurtzman and is used to determine whether or not government action violates the Establishment Clause of the First Amendment. The test requires that 1. A policy have a primary secular purpose, that 2. A policy not cultivate an indefensible legal weapon against non-observers of a religion, and 3. That a policy not excessively entangle the government with a particular religion. According to the United States Supreme Court, if government action fails one prong of Lemon, it's unconstitutional under the Establishment Clause. The Establishment Act reflects the fact that policies that promote, respect, endorse, and favor LGBTQ ideology and sexual orientation orthodoxy fail all three prongs of the Lemon Test by a landslide. For one, they constitute a non-secular sham that lacks a primary secular purpose, putting the religion of secular humanism over non-religion and over other religions. 2, those policies cultivate an indefensible legal weapon against non-observers of the religion of secular humanism. And 3, those policies tend to excessively entangle the government with the religion of secular humanism as advocated by the LGBTQ cult, which means that those policies always have been and always will be unconstitutional. This means that the Establishment Act invalidates any marriage policy that does not involve one man and one woman, any policy that prohibits conversion therapy, any policy that punishes discrimination on the basis of sexual orientation in the private sector, like the COTA statute in Colorado, which the Colorado Civil Rights Commission has used repeatedly to mercilessly persecute Jack Phillips under, any policy that would allow an individual to change their birth certificate, driver's license, or any other official government document that does not accord with the biological anatomy that they were born with, any policy that forced the private sector to allow biological males to use a female restroom based on their non-secular, self-asserted sex-based identity narrative, any policy that forced a prison to house biological males with biological females based on their non-secular, self-asserted sex-based identity narrative, any policy that allows for taxpayer dollars to pay for sex reassignment surgery, any policy that requires a health provider or an insurer to cover or provide a procedure that respects transvestite dogma, any policy that mandates pronoun changes out of respect for the LGBTQ cult, any policy that would allow for a public school to teach or promote LGBTQ ideology, any policy at a public school that would allow biological male students to participate in an all-girls sports out of respect for their non-secular, self-asserted sex-based identity narrative, any policy that allowed a public building to display the LGBTQ flag in a manner where it would be unlawful for the building to display the symbols of institutionalized religions, and any policy that would allow a public library or public elementary school to host and sponsor drag queen story time for children. All of those policies are unconstitutional pursuant to the First Amendment Establishment Clause. The Establishment Act permits taxpayers to bring a civil right of action against any state actor that continues to create or enforce policies that promote LGBTQ ideology. In a lawsuit brought under this act, a plaintiff can seek injunctive relief, attorney's fees, costs, and other forms of relief. A state actor who is a defendant in civil litigation brought under this act cannot raise sincerity of belief in LGBTQ ideology as a valid defense. This is because there's a long-standing jurisprudence that emotional appeals, even really good ones, cannot be used to usurp the Establishment Clause of the First Amendment of the United States Constitution. The Establishment Act makes clear that the government will continue to enforce man-woman marriage policies because man-woman marriage and man-woman marriage policies are natural, neutral, and non-controversial. They're secular in nature. They don't put religion over non-religion. They actually accomplish their intended purposes. They're not a political power play, a ploy, or a sham. Man-woman marriage policies do not erode community standards of decency. They don't promote licentiousness, and they're not an attempt to justify practices that are inconsistent with the peace and safety of the state. To eliminate any ambiguity, the Act defines secular marriage to mean a legal union that represents an intended lifelong commitment between one person who was born a biological male and one person who was born a biological female as husband and wife, who are of equal but opposite genders, who become spouses of the opposite sex, and who have corresponding sexual anatomy that, if coalesced, have the actual or symbolic potential to create offspring, who will likely have the input of the two spouses with whom they share the same genetic code and unbroken ancestral chain with. No other relationship on the planet is like that. And the fact that we have to go to that extent to define secular marriage is pretty outrageous. But many aspects of the left have become so intellectually dishonest that we don't want to give them any more wiggle room. And the government has compelling interest to set apart man-woman marriage for secular reasons. In another section of the Establishment Act, it is stated that pursuant to the Free Exercise Clause of the First Amendment of the United States Constitution, the government cannot discriminate against an individual because they believe in the plausibility of LGBTQ orthodoxy and engage in its practices. Likewise, the bill prohibits the government from discriminating against an individual who finds LGBTQ ideology to be absurd and its practices immoral. The bill does make clear that while the Free Exercise Clause of the First Amendment of the United States Constitution does provide some limited protections for LGBTQ secular humanism, in the same way that it provides some limited protections for the KKK or Islamic jihadists, that the Free Exercise Clause is not absolute. LGBTQ secular humanism does constitute a disfavored religion to some extent. It does promote obscene speech, spread licentiousness, and has a tendency to erode community standards of decency. The government has a narrowly tailored, compelling state interest to uphold community standards of decency, and the government has a rational basis to restrict LGBTQ practices on that basis alone. Despite irrelevant feelings, the bottom line is that the government's entanglement with the LGBTQ cult has proven to be a total disaster. We have learned that people who are intolerant of intolerant people are intolerant, and people who are judgmental against judgmental people are judgmental. And when a person says that love is love, what they really mean is that they're perfectly okay with government assets being used to crush anyone who dares to believe that homosexual orthodoxy is immoral and subversive to human flourishing, even though deep down everyone knows that it is. The fact of the matter is that love without truth is just shallow sentimentality. By enacting the Establishment Act on either the state or federal level, it will serve as a catalyst to overrule Obergefell versus Hodges and Windsor versus the United States. Those decisions were resolved before the Supreme Court in 5-4 splits, where dissenting judges like Justice Roberts stated, "Just who do we think we are?" Justice Scalia called the combined cases an egotistic judicial putsch, stating in his dissent, "I write separately to call attention to this court's threat to American democracy." Obergefell and Windsor decisions constitute the greatest sham since the inception of American jurisprudence. The Windsor decision led to the Obergefell decision. Obergefell was the case where the U.S. Supreme Court held that marriage was a fundamental civil right for homosexuals, while failing to realize that from a legal perspective, there's no such thing as a homosexual. There's only some people who self-identify as homosexual for some period of time, as the Free Exercise Clause of the First Amendment permits. But the majority on the Supreme Court in Obergefell were not wrong, in that the United States Constitution is not silent as to which types of marriages the government can legally recognize and respect. The court was just deciding the matter under the wrong constitutional narrative. The evidence shows that the controlling constitutional prescription when it comes to sexual orientation orthodoxy is the Establishment Clause balanced with the Free Exercise Clause of the First Amendment. In Obergefell, self-identified homosexuals filed a lawsuit pursuant to the 14th Amendment, asking the courts to force the states to legally recognize and respect gay marriage, which allows self-identified homosexuals to draw a constellation of benefits at the taxpayer's expense based on identity narratives that are inherently religious. The 14th Amendment is divided into two parts, the Equal Protection Clause and the Substantive Due Process Clause. But the Equal Protection Clause can only be invoked if the matter at issue involves immutability in genetics. And there's countless medical experts whose studies show that just as there's no rape gene, there's no gay gene. And there's thousands of ex-gays and ex-transvestites who have left behind the LGBTQ cult completely. Skin tone is actually based on genetics and immutability, and that's why the 14th Amendment prohibits the government from discriminating on the basis of race. And while there's no such thing as an ex-black person, there's thousands of ex-gays. And the Supreme Court in Obergefell pretended that ex-gays don't exist, relegating them to non-existent citizens. So the objection with the government's entanglement with the LGBTQ cult is based off of secular biology, not bigotry. And for anyone to suggest that the phony gay civil rights movement is equal to the race-based civil rights movement, whereas the race-based civil rights movement was actually based on immutability and genetics, is guilty of an extreme act of racism in kind and racial animus that manages to be racially, sexually, emotionally, and intellectually exploitative. The 14th Amendment is extremely important to people of color and is not to be hijacked by political opportunists. Black Americans used to have to ride on the back of the bus, drink from the other water fountain, and walk to school. To compare skin tone to sexually immoral practices is incredibly offensive to millions of people of color. So what about the applicability of the other element of the 14th Amendment, substantive due process? Substantive due process can only be invoked if the matter involves American history and tradition. And the history of homosexuality is that it was basically illegal until 2003 when the Supreme Court in Lawrence overruled Bowers. So matters relating to homosexuality, transgenderism, and sexual orientation have nothing to do with the Equal Protection Clause or Substantive Due Process Clause of the 14th Amendment. They have everything to do with the religion of secular humanism. But our government is not a church, it is not a redeemer, it is not an instrument to be used to justify the moral plausibility of LGBTQ practices, and the off chance that those who believe in LGBTQ ideology will feel less ashamed and inadequate about practices that naturally produce feelings of shame and inadequacy. The entire thing has been a sham. If marriage really was an individual, existing, fundamental right based on a personal, autonomous choice, in view of the 14th Amendment's Equal Protection and Substantive Due Process Clause for self-identified homosexuals, then marriage must be an individual, existing, fundamental right based on a personal, autonomous choice, in view of the 14th Amendment's Equal Protection and Substantive Due Process Clause for self-identified polygamists, zoophiles, and objectophiles. But since that's not the case, and polygamy is still illegal, the entire thing is a complete sham. It was always an unprincipled ploy designed to hijack the 14th Amendment and exploit emotion, in order to coercively make secular humanism the national religion, to ratify the moral superiority complexes of moral relativists, who have banked their entire life on the idea that God doesn't exist, and that there are no moral absolutes. So the Establishment Act will be the catalyst that will lead to Obergefell versus Hodges being overruled, and it's important to identify how that will happen. Many Republican lawmakers in the wake of Obergefell have attempted to introduce legislation that is based on emotion, framed wrong, and preempted by the decision in Obergefell. All of those policies are unconstitutional in view of the doctrine of preemption and stare decisis. Stare decisis means this: once the Supreme Court of the United States has made a decision, the issue is decided. The Supreme Court cannot be expected to relitigate the same issue over and over again. So once the Supreme Court makes a decision, it's water under the bridge. However, there's a couple of ways to get the Supreme Court to overturn past decisions in view of two legal principles. Number one, in a prior case, if the court was asked to make a decision by interpreting the Constitution, then stare decisis is at its weakest. In Obergefell, the court merely interpreted the Constitution of the United States in determining whether state statutes that limited marriage to one man and one woman were constitutional under the 14th Amendment. This means that stare decisis is at its weakest when it comes to saving Obergefell. Number two, in a prior case in controversy, if there were other constitutional issues that were lurking in the shadows that were undecided upon, then stare decisis does not apply at all if the case is brought back to the court under the correct and controlling constitutional prescription. This means that stare decisis will not even apply when a lawsuit is filed by the LGBTQ cult after a state enacts the bill and the matters are represented to the federal courts. The courts will uphold the Establishment Act and overrule Obergefell because it's based on the correct and controlling constitutional framework. It took almost 100 years for the Supreme Court to overrule Plessy versus Ferguson and Brown versus Board of Education. By enacting the Establishment Act, it could take less than 5 years for the court to overrule Obergefell. And it's about time. In the wake of Obergefell, there has been no land rush on gay marriage. There has been a major land rush by devout secular humanist activists to socially marginalize and even violently oppress non-observers of their religion, especially Christians. In the wake of Obergefell, there's been no land rush on gay marriage, but there's been a major land rush by devout secular humanists to infiltrate public elementary schools and public libraries with the sole purpose of targeting children to indoctrinate them with the LGBTQ secular humanism with a government stamp of approval at the taxpayer's expense. It's an evil that the Establishment Clause of the First Amendment does not allow. Under the Free Exercise Clause of the First Amendment, a person can still self-identify as a homosexual, they can still live that lifestyle, they can still have a wedding ceremony with a person of the same sex, they can still have transvestite surgeries, but the government cannot respect it, endorse it, promote it, or favor it. The government must not recognize the plausibility of non-secular self-asserted sex-based identity narratives or sexual orientation orthodoxy because they're religious doctrines. Every American should get behind the Establishment Act because it will restore the rule of law, restore constitutional supremacy, and stop the left from legislating immorality in a manner that has cultivated a dangerous cultural civil war.